very much.
Yes, Mr. Phillips.
Please, your lordships, I appear with my learned friends, Mr. Wilson and Mr. Newey, on behalf of SLP3 and LBHI. My learned friend, Mr. Arden, appears with Miss Foskett on behalf of LBHI2. The joint administrators of PLC are represented by my learned friends, Mr. Beltrami and Mr. Kramer. My learned friends, Miss Delaney, Mr. Fisher, and Mr. Goldfarb appear on behalf of Deutsche Bank, and the joint liquidators of GP1 are represented by my learned friends, Miss Hilliard and Mr. Roscoe.
Yes. I can tell you that we have read the judgment several times. We have read the skeleton arguments and the notices of appeal. I'm bound to say that before reading into this, I thought that every conceivable question about insolvency had been asked and answered in the course of the Lehman administration. But I was obviously wrong.
My lords and my lady, if every question on insolvency had been answered, it would be a very sorry day for my set of judges. So, my lords, my lady, thank you very much, my lord, for that invitation. Like all of the subordinated instruments in issue in these appeals, the LBHI2 subdebt and the LBHI2 subnotes were dated subordinated instruments which were issued for regulatory capital purposes to different entities within the Lehman Group. There is no clear expression in any of these instruments that they were intended to rank anything other than pari passu as between each other. And no party has identified any regulatory or commercial reason why Claim A and Claim B should rank anything other than pari passu. In our submission, a pari passu result is the unsurprising and fair outcome. At the outset, my lords, my lady, we want to remind you of the basic parameters of subordination of debt, if I may. In a winding up or a distributing administration, rights to payment under a contract are replaced by rights of proof and distribution in the insolvency. The Insolvency Act and rules mandate how debts are proved, how they are valued, what distributions they receive, and what interest is paid on the debts proved. Debts will rank pari passu unless a particular debt is effectively subordinated to other debts. Those rules cannot be altered by agreement between the creditors and the debtor. What may be altered is the creditor's rights. A debt may be subordinated by contract or by using a trust mechanism. Determining priorities concerns identifying the subordinated creditor's right to prove and the nature of their debt. The right to prove is determined by the contract. A creditor may agree that it will not prove its debt until after other creditors, the senior creditors. The effect of such an agreement is that the senior creditors will receive distributions and statutory interest before the junior creditor is entitled to prove. The judge used the label simple contractual subordination, as you will have seen, to describe this. It is not possible for a creditor to provide that its debt will be paid in priority to another debt, unless all those who would rank junior agree, because such an agreement would infringe the principle that provable debts abate equally and shared distributions pari passu. Since British Eagle, it has been recognised that this is a principle of public policy, and it is presently enshrined in Rule 1412. The nature of the debt is also determined by the contract. It may be actual, future, or contingent. The rules applicable in the insolvency provide how each of these different types of debt are proved and valued. Turning to the relative ranking of the LBHI2 sub-debt and the unamended LBHI2 sub-notes, our submission is that the claims under these instruments rank pari passu, and the judge erred in our submission by concluding that Claim A ranks below Claim B. As we explain in our skeleton argument, we run two alternative cases. First, what we describe as ineffectiveness of subordination provision inter se, which is the learned judge's approach, and second, same senior creditors or senior liabilities. And I'll expand on these, of course. In essence, either on the judge's approach...
Right, what was the second one?
Sorry, my lord. Same senior creditors or senior liabilities. I will expand on it.
Yeah.
The proposition is relatively straightforward, which is where two debts have subordinated themselves to the same senior creditor, they prove at the same time, and by virtue of the rules, they rank pari passu. In essence, either on the learned judge's approach to construing subordination provisions, but applied properly, we say, to the LBHI2 priority dispute, or on our trial case, which is the second basis, Claim A and B prove at the same time and rank pari passu. We will deal, minor diversion, we will deal with Deutsche Bank's dividend stopper in due course, insofar as they have permission to run that argument, but that's a debate for later on the PLC appeal. And just so that you should be aware, we do not accept that Deutsche Bank has permission to run the dividend stopper argument, as the judge specifically ruled it, refused it permission and made clear that it's not an argument of construction, and the judge also specifically rejected the dividend stopper argument on the facts. As I've said, we will come back to that. For the purposes of the LBHI2 appeal, there is no basis to apply the dividend stopper argument to the LBHI2 ranking dispute. And just to make this additional point, dividend stopper aside, you should be aware that Deutsche Bank were joined on an undertaking that they would not duplicate Mr. Beltrami's arguments. And I'll just give you, by way of a note, in AB3, tab 57, 1803, paragraphs 14, 16 and 17, is Mr. Justice Mann's joinder decision. And the reason why I make these points is that we are proceeding on the basis that Deutsche Bank will not be repeating anything at PLC, any of PLC submissions, and we are focusing primarily on PLC submissions. I just wanted to make that. We now turn to two topics. The first topic is the judge's approach to the mechanics of subordination in the relevant instruments. He held that subordination was effected by a combination of two separate mechanisms: simple contractual subordination and contingent debt subordination. PLC's case focuses on the conditionalities in the instruments, which PLC describes as the operative subordination provision. And they give primacy to the conditionalities. And in our submission, both the judge and PLC's analysis is incorrect.
I thought, reading the skeletons, that both you and Mr. Beltrami agreed that chopping the subordination provisions up into bits wasn't the right approach, and that they needed to be read together.
They do, and the extent to which there is agreement is something, if I may respectfully develop, my lord. But your lordship's absolutely right. The simple proposition is there is a single subordination provision in this contract. It must be construed as a single subordination provision.
And thus effect given to all, as much of it as can be given.
Absolutely, my lord, and your lordships will not be surprised, and your ladyship, I apologise, will not be surprised to hear that we will be submitting that the way in which we construe these clauses does give effect to absolutely everything in those clauses, and they are consistent in that what they provide, both in the conditionalities and in the subordination provision itself, is that the debts are subordinated to the senior liabilities as defined. I'll develop that, of course. The second topic is the judge's approach to and construction of the simple contractual subordination. And this is the part of the subordination provision that defines or refers to which liabilities each instrument is subordinated. And we've described that as the definitional wording issue. So those are the two issues. If I may turn to the conditionality issue first. The key point of difference between us and PLC on the conditionality issue is that PLC argue that the subordination is effected by the conditionalities, which follow, as you've seen, the definitional wording in the relevant subordination provisions. And they attach no weight to the definitional wording. And in our submission, the definitional wording, in other words, who are the senior creditors, is central to construing these subordination provisions. It defines the senior creditors or the senior liabilities to which the debts are subordinated. The mechanics of subordination, in other words, the interplay between the contractual and the contingent, is an issue that cuts across first and second grounds of appeal. And PLC's case in relation to both is that the unamended subnotes and the amended subnotes turn on treating the respective conditionalities in those agreements as having a freestanding and independent effect, notwithstanding, my Lord, the point that your Lordship just put to me. And their argument is that they have a freestanding and independent effect, regardless of the definitional wording. In our submission, the judge erred in breaking up a single subordination provision and treating it as being comprised of two separate, independent, and you will see different mechanisms, which could each dictate separate and potentially inconsistent ranking outcomes. In our submission, the subordination provisions in both the LBHI2 subdebt and the LBHI2 subnotes should be construed as a whole, producing a single ranking outcome. And the judge ought to have rejected PLC's core proposition that the conditionalities altered, or even could alter, the meaning of the definition of senior creditors. And if PLC is wrong on its thesis that the conditionalities, the conditionalities which effect subordinating, their case on both the unamended subnotes and the amended subnotes doesn't get off the ground. Both cases depend on the independent primacy of the conditionalities. And my lords, with that, as it were, as an overview, what we would like to do now, before turning to the detail of the subordination provisions, is to look in a little more detail at the statutory scheme. My lord, I hope you'll forgive me for doing that. The judge, in paragraph 122, and I don't need to turn this particular paragraph up, was right to find that the subordinated claims in this case are provable debts. I just wanted to start with the proposition, these are provable debts. We don't have to get into the thorny question about non-provable debts. The interplay between the statutory scheme and the subordination provisions is central to these appeals. That is because creditors' rights to payment in an insolvency can only operate within the statutory scheme. And that is a core proposition. Rights to payment can only operate within the statutory scheme. And if you could go to bundle A, Authorities Bundle 5, I just want to draw attention to some propositions that we've made in paragraphs 20 to 21 of our skeleton by reference to the rules. If you would be kind enough to go to tab 80 in Authorities Bundle 5, and I will start at 2531, the numbering in the bottom corner. This is Rule 14.3. 1. A creditor wishing to recover a debt must submit a proof to the office holder, and then there are some exceptions which are not material. The critical point is that a creditor wishing to recover his debt, and that's of course a very important point, must prove their debt. They may choose not to prove, or they may choose to prove late, or they may choose to prove after other creditors have proved and received dividends. A very important point that I will come back to when we look at MCC. Then, if we could go 2 pages back to 2529, and it deals with 14.2, all claims by creditors except as provided in this rule are provable as debts against the company or the bankrupt, whether they are present, future, certain or contingent, ascertained or sounding only in damages. And as I said to you, these were provable debts. And as my Lord Justice Lewison will know, a contingent debt can prove at any time. And if we could then go to 2535. This is Rule 1414, which deals with the estimate of value of debts. In an administration or in a winding up, the office holder must, please note, that is mandatory, estimate the value of a debt that does not have a certain value because it is subject to a contingency or for any other reason. So it is mandatory. A contingent debt that is proved must be valued. Now, PLC seek to minimise the importance of the statutory scheme with respect that is misguided, because the statutory scheme is the scheme by which creditors in an insolvency can be paid, and the subordination provisions are concerned, as you will see, with the right to payment. There are 2 ways in which my learned friends seek to minimise it, and if we could take bundle C1, tab 8 is my learned friend's skeleton. I would have suggested leaving it out the whole time, but I'm afraid there are a few files we'll be dipping in and out of. But if we could start on page 103, they seek to challenge the centrality of the pari passu.
Sorry, which page?
103, my lord.
103.
103. Apologies. And it's in paragraph 14, in which they say that we set much store by the existence of Rule 1412. Its main theory is the exercise of contractual interpretation necessary to determine the ranking issue is skewed by the existence of the default rule of pari passu ranking. As to that, the starting point is that provable debts can prove at any time. An agreement by a creditor to subordinate their debt operates as an agreement to defer the creditor's right to prove after the senior liability has been paid in full. And where it is unclear or equivocal whether two debts have agreed to defer their rights to prove vis-a-vis each other, the right to prove at any time has not been displaced, and the creditors continue to be entitled to prove at the same time as each other. And if they prove at the same time as each other, they will rank pari passu under Rule 14.12. And that my learned friends go on in 15, where they go on to say that the relevance, if we look at the last sentence of paragraph 15, where this train of thought goes, the relevance of Rule 14.12 is that it's engaged in a gap-filling role if the contract runs out. It does not assist in the determination of what the contract actually says. Well, there are really 2 points in relation to that. First of all, to describe a core principle of the insolvency process as a gap filler is frankly extraordinary. Contractual subordination, as I hope I have already shown you, can only take effect within the context of the statutory scheme. And as to the significance of pari passu, could I ask you to take up Authorities Bundle 2, please, at tab 33. And that's at page 752.
Is that 52?
That's for 53.
Yeah.
I'm so sorry.
Golden Key.
Yes, Golden Key, which you can see is a decision of Lord Clark, Lady Justice Arden and Lord Justice Lloyd. And I just wanted to show you 2 paragraphs, 5 and 6. Paragraph 5, which is on, say, at 755, where it deals with pari passu provisions are often commonly found in debentures. A provision for pari passu repayment can, however, be implied if it's clear that the debenture holders are to stand on an equal footing. So that indicates to you, as it were, another approach to the core understanding. Accordingly, where a document on its true interpretation provides for the distribution of assets in a group to persons as between whom no distinction is to be drawn, the court will imply a requirement to make distributions proportionately, even though the words equally or pari passu are not used. And I'm sure this is something that will be well known to you. The pari passu principle and this sort of approach goes back to equality is equity. And along, that's where this comes from. Such an implication is not, however, possible where the document evinces an intention the distribution should be on some other basis. Given its importance, the concept of pari passu can be taken as part of the background to the issue of the ECP. That would have been known, that's the commercial paper, would have been known to the parties. And then picking it up, the concept of pari passu distribution may also be a factor which makes one interpretation more plausible than another.
Okay, can I just ask you this, Mr. Phillips?
Of course.
I mean, as you can imagine, the 3 of us have been discussing this case before we started. And we were all a bit puzzled by what contractual principle the judge applied in breaking the so-called race to the bottom. But I think your answer, as you've been developing it, is it's not really a contractual principle, it's the rules.
It's the contract is ineffective in that you've got two subordination instruments that say you're senior to each other, and where you've got 2 provisions that do not subordinate one to the other, that's ineffective to displace, as your lordship says, the pari passu principle. The learned judge described it as ineffectiveness. However one wants to describe it, that's what he's saying is there is no clear and effective subordination in one or the other as between the two of them. Does that help your lordship?
Yeah, but I think what you're really saying is that unless subordination of 1 to 2 or 2 to 1 is clear, then the rule prevails.
Yes.
Because they're both contractually, if you like, left in limbo, and accordingly, the only way you deal with it is through the rules. If there had been some express, I'm sorry to be so basic, this is what you've said, but if there were some express contractual term, then you could see that 1 was over 2 or 2 was over 1. But there is none, so they're all in the same boat. They're all in the same bucket, and accordingly, you look to the rules. That's what you're saying.
Yes, my lady.
And would another way of making the same point perhaps be to say that referring to it as a default provision can be dangerous, because it rather suggests it's something you rather put at the back of your mind and listen until you're driven to that, whereas rather it's both the starting point and the end point, unless you find a very clear contrary provision.
Absolutely, my lord. Absolutely. Forget default, forget gap filler. Those aren't helpful as labels. May I go on to my second point, which is that PLC ignore the significance of proving in the context of subordination. And if we could go back to Core Bundle 1, to paragraph 47 of their skeleton, which is at 113, tab 8, 113. What they...
Wait, which paragraph?
47, my lord.
47, yeah.
Apologies. And what they say, and I'm looking at the statement 5 lines up from the bottom, they say SLP3's focus on proving as a matter of insolvency process is unnecessary and potentially misleading. And as to that, could I go back to Appeal Bundle 5 and to Rule 14.3, which is tab 80, 2531. Just remind your lordships, or maybe you don't need to turn it up again, a creditor wishing to recover must submit a proof. It's not unnecessary and it's not misleading in any way. It's the context in which these provisions operate. A creditor cannot obtain payment through any other mechanism. And that's really important. And when subordinated debt agreements refer to prohibitions on payment being made on the subordinated debts, in an insolvency context, that is necessarily a reference to proof, given that it is, as I've shown you, only by proving that one can be paid a dividend. And this is also made clear by GEMPRO. If I could just ask you to go to tab 81 in Bundle, Authorities Bundle 5. If we could go to 2552, this is the prudential source book pursuant to which the subordinated instruments have been produced. And I just wanted you to see Rule 2.2.159 sub-rule 3. To the fullest extent permitted under the laws of the relevant jurisdictions, the remedies available to the subordinated creditor in the event of non-payment or other breach of the terms of the capital instrument must, mandatory, be limited to petitioning for the winding up of the firm or proving for the debt in the liquidation or administration. So it's all of a piece. It's a whole structure. The remedies available to the creditors are that they can wind up, or of course, if it's in an insolvency, they can prove, and you've seen that proof is necessary to receive payment. In our submissions, my lords and ladies, the core subordination question arising in an insolvency is below which senior creditors do they prove? And for your lordship's note, it's in paragraph 46 of our appeal skeleton. And that question is answered by looking at how the senior creditors are defined. In contrast, PLC's approach turns on having the conditionalities dictate relative ranking without any regard to the definition of the senior creditors to whom the subordinated creditor has subordinated itself. And we'll see later, and I will develop it later, that their submission terms the senior creditors, who are as defined, as to all creditors. We'll come back to that. The next thing, my lords, I would like to do, and I'm sorry, I'm dealing with a number of the building blocks, if I may, is I want to take your lordships through two important cases on subordination, which are the MCC case and Waterfall 1. And if I could turn to Authorities Bundle 1 at tab 17 first. This is the decision of Mr. Justice Weinlott in 1993 in Maxwell Communications Corporation. And it is a foundational judgment in relation to subordination. In MCC, the question was whether the holders of subordinated debt could be excluded from a scheme of arrangement. If the subordination provision was effective, they could be excluded. If it was not effective, they could not be excluded. And if I could first show you the subordination provision, which is on internal page, well, in the bundle it's page 304, it's in internal page 1405H. If I can just show you the subordination provision to start. Under the guarantee, MCC undertook to pay on first demand by SPC in summary, event of default, the paid up value of the outstanding bonds with interest. It provided that the guarantee of payment of the nominal value, in the case of event of default, paid up value, and interest with regard to the bonds and the paid up value of the preference shares under this guarantee constitutes an unsecured and subordinated obligation of the guarantor, in that, in any case of any distribution of assets by the guarantor, whether cash or otherwise, in liquidation or bankruptcy, and so on, I'm picking it up just above B, creditors of unsubordinated indebtedness of the guarantor shall be entitled to be paid in full before any payment shall be made on account of payments under the bonds or the preference shares, but that payments to bondholders, coupon holders, and preference shareholders shall be made before any payment shall be made in such cases to the holder of any class of stock in the guarantor. Now, it was a contractual subordination provision, and the reason for that is there is no trust law in Switzerland. And that provision was found to be effective, absent some other form of conditionality. And if we can go to 1411G, which is on 310 of the bundle, if I can...
Starting, the question is?
The question is, yes, my lord. And one of the reasons why this was such a major question at the time is that post-British Eagle, there was a question as to whether or not public policy meant that you couldn't have any form of subordination. That was the big issue at the time in '93. So the question is whether this underlying consideration of public policy should similarly invalidate an agreement between a debtor and a creditor, passive owning or subordinating.
You don't need to read it aloud, Mr.
Oh.
Phillips. Just tell us what you want us to read. You want us to go from
thank
G
you.
down to the end of the sideline.
G down to the end of just above letter C on 1412, please. Thank you. I apologise. I meant to do that. So my lords, my lady, you can see that Mr. Justice Vinelock's reasoning was, well, if a creditor can choose whether or not he wishes to prove his debt at all, why can't he decide not to prove until some other individuals, some other creditors have been paid? And if he can do that, why can't he pre-agree to do that? And that was his reasoning. And then if we can move forward to 417 at B, I just want to show you, if you could, yes, at D, and I'm not asking.
I'm sorry,
so
tell me where I'm looking again.
Oh, it's on page 316. It's internal
Thank you.
number 1417. I just wanted to say at letter D, he moves on to ex parte Villiers, which was a decision in South Africa, and he was looking at the decision of Justice Goldstone. And if you could pick up, please, at 1417F to 1418B, if you wouldn't mind just reading that passage.
Yeah. What's the proposition you
And
get
there are
from
two,
this?
yes, sorry, yes, two. The first proposition is that 1417G is PLC's argument in this case. Enforceability made fulfilment of conditions and so on. And at 1418A to B, it is noteworthy that Justice Goldstone said that the suggestion that a value should be put on a contingent debt, that is not correct. And you will see, and my lords, I'll point this out, that Lord Neuberger in Waterfall 1 held that you do put a value on those debts. And then in 1418F to H, the proposition there is that Mr. Justice Vinelock expressed doubt as to whether subordination turns a debt into a contingent liability. And perhaps rather than spend the time now, if you could just note that.
Wouldn't that depend on the terms of the instrument creating the debt?
My Lord, of course it does. You could create a contingent liability, but we'll see that debate is picked up and run with. Can we then move to Lehman's Waterfall 1? And I want to start, if I may, in the Authorities Bundle 3, tab 51. My Lords, I hope that you will forgive me for taking you through first instance Court of Appeal and Supreme Court, because in our submission you cannot really understand what the Supreme Court did without seeing the previous debate. And of course, my Lord Justice Lewison wrote the lead judgment in the Court of Appeal, so I'm acutely conscious, my Lord, that you will be very familiar with this.
Yeah. Well, Mr. Justice David Richards explains the regulatory capital regime extremely clearly at first instance. And I think that's particularly valuable.
Absolutely. Now, the first point to note is that Waterfall 1 addressed subdebt in the same form and for the same amounts as the LBHI2 subdebt in this case. It was, whether you describe it as one up the chain or one down the chain, it was in the same chain of regulatory capital within the Lehman's companies. And that's an important point to have in mind, of course. The courts were looking at the same subdebt terms. PLC argues that the decisions were confined to a very narrow argument concerning Rule 2.887. That, with respect, is incorrect. Mr. Justice David Richards and the Court of Appeal and the Supreme Court were concerned more broadly with how subordination under Clause 5 of FSA Standard Form 10 operated, and whether it was subject to a form of contingent debt subordination. So if I could ask you to cast your eyes over on page 1463, Ms. Justice David Richards' judgment. If you could cast your eyes over holding number 1 on 1464. And my Lords, you can see the conclusion on a true construction. The subordinated debt agreements had the effect that the subordinated loan creditor claims were subordinating not only to provable debts, but also to statutory interest and provable liabilities.
On a true construction means on a true construction of the instrument, not the rules.
Yes. But the instrument operates within the rules.
Of course.
Of course, my Lord. No, absolutely. And this is significant, as your Lordship will see, the debate develops when one then looks at what Mr. Justice Marcus Smith has done with this very same instrument. And that's one of the main reasons why I'm taking the Lordship through this. Could you turn to paragraphs 16 and 17 on 1480 and perhaps just note that what Mr. Justice David Richards does in those paragraphs is he describes the process of proof and valuation, which, as you know, is the process that is mandated by the rules, perhaps one that you would look at later. But then paragraph 33, 1484, where Mr. Justice David Richards explains that the subordinated loans formed part of the regulatory capital, and as your lordship has already indicated, he then goes on to explain the capital adequacy rules regime, and really this is for your note in 43 through to 46. There is a very helpful description of the tiers of regulatory capital, and in the present case, all of the subordinated debt was lower tier 2 or possibly tier 3. And you fall into the different tiers depending upon the terms of the various debt instruments. So that, for example, tier 3 is going to be shorter 2-year subordinated debt, just by way of example. And then, if I may pick it up, in 48, where Mr. Justice David Richards...
Sorry, just before you move on.
Yes, of course.
Do the capital adequacy rules prescribe for relative priorities as between the 3 tiers of capital, or the 3 tiers and 2 sub-tiers?
There is one reference that I will draw to your attention in due course, which provides that tier 3 ranks pari passu with lower tier 2 debt. There's one reference, but otherwise, of course, my lords, I'd have taken you straight to it.
Yeah.
Then in 48, what Mr. Justice David Richards notes in 48 is that each of the subordination provisions were based heavily on the template provided by the FSA. And the significance of that is that what the court was construing was clause 5 of FSA Standard Form 10, which is clause 5 in the sub-debt in this case. And my lords, you can see that in paragraph 53 where clause where clause 5 is set out. And then if I can move on to paragraph 60. If you could just note that Mr. Justice David Richards says, in approaching the issues of construction of subordinated facility agreements, clearly right to have regard to their regulatory context. And then, my lords, again, for your notes, but can we then move on to 63? All of this is consistent with the concept that subordinated loan capital qualifying as part of the institution's regulatory capital is, as against creditors, to be treated as part of the capital. It is not, of course, part of the share capital, and it ranks ahead of share capital in terms of repayment. And my lords, the lordship should obviously note that if it's debt, it ranks ahead of capital. 3 points, but for your notes, if I may just make them. Paragraph 77. Mr. Justice David Richards set out the rights of contingent and future creditors. And then in, again, for your notes, in 81 and 82, Mr. Justice David Richards set out the development of how contractual subordination works, and you'll note in paragraph 82 that he refers to MCC. Now, please don't put away Authorities Bundle 3, but I just wanted to look at the order, Mr. Justice David Richards' order, which you will find in Authorities Bundle 5, tab 84. 2784. And my lords, it is important in order to understand, as it were, what happened next. So the declaration that Mr. Justice do you have 2874, which is tab 84?
Yeah.
Thank you. The declaration was, I'm picking it up in line 3, are subordinated provable debts, statutory interest and non-provable liabilities, all of which, other than the claims of LBHI2 under its subordinated loan agreements and statutory interest thereon, must be paid in full before LBHI2 is entitled to prove and require the LB administrators to admit such proof in respect of its claims under its subordinated loan agreements with Libby. So that's the declaration made by Mr. Justice David Richards.
I'm so sorry, which subparagraph was that?
Oh, I'm so sorry.
No, my fault entirely.
No, it's one, my lord.
The one, thank you. On
It's
page 2874.
2874, it's one, my lord.
Yep.
And you can stop at before it goes on to B.
Yes, thank you very much.
So against that background, could I turn to the Court of Appeal decision?
Yeah, it was that declaration which the Supreme Court reinstated.
It is, my lord, and that's why I'm doing this. It's so that your lordships can fully understand exactly what happened in relation to contingent debt analysis.
Yes.
In order to understand what the Supreme Court did, and I appreciate, my lord, for your lordship, that's not that is going to be relatively straightforward because your lordship wrote the leading judgment in the Court of Appeal.
Yeah, well, I was wrong on that.
My lord, I just it's not for me to put any sort of subjective intention in relation to what the Supreme Court said about your lordship's judgment. There it is. That's what the Supreme Court has said. The first point to flag in relation to the Court of Appeal.
You're going to the Court of Appeal now?
Oh yes, I am. I'm so sorry. It's in Authority 3 at tab 53. So
yes.
The first point to flag from the head note is that I respectfully submit it is actually notable that Maxwell was not referred to in the judgment nor in argument. It had, of course, been referred to in Mr. Justice David Richards' judgment, as you have seen, but it does not appear to have been referred to the Court of Appeal in argument. As to, if you could turn to holding 1, and if you'll forgive me for just going through this with your lordships. Holding 1 is that an administrator's obligation under 280.887 to pay interest, not merely a direction, so you're dealing with that point. And just picking it up further down, where it says, at C, the subordinated debt was thus repayable on contingencies, which included payment of statutory interest and of any non-provable liabilities, and any valuation of the contingent debt had to take account of both contingencies, and that accordingly, under the agreement, the subordinated loan creditor claims were subordinated not only to provable debt, but also statutory interest and non-provable interest. The point that I wanted to draw to your lordship's attention is that the decision of the Court of Appeal was that the subordinated debt was payable on contingencies. And of course, my lord, it's your lordship's decision, and your lordship will be well aware of that.
Well, the dispute was whether it was provable.
Absolutely. And
I thought it was, and the Supreme Court said it wasn't.
That's absolutely right, my lord. Can I, because I it's interesting, I was wondering at what point I might need a tin hat. But,
So your tin hat, I quite often get things wrong.
the argument which was run, and this is very ironic, when you go through the waterfall decisions, there is an array of talent, but the argument that was run, which persuaded your lordship, was an argument of Mr. Snowden, as he then was. And the argument that he was running was that the debt was contingent, and so the subordinated debt could prove. And having proved, when there was a surplus over the principal unsubordinated debt, the contingency would be revalued, the subordinated debt would be paid before the interest under 288. That was the argument. In fact, you can see that argument on 1588. It's at 59 C to D. You see Mr. Snowden, as he then was, his argument. And my lords, that argument was then picked up. If we could go to 1603, paragraph 38. And again, if you'll forgive me for just going through this. In my Lord Justice Lewison's judgment, what you said is there are a number of different ways in which subordination agreements can be drawn, and you there deal with the different, summarise the different methods of subordination. And then it's really just below letter F. In my judgment, clause 5.1 means that the right to repayment of the subordinated debt is a contingent right, contingent on the satisfaction of clause 5.1b. And if appropriate, clause 5.1a as well. It is that sentence, my lord, because that is precisely what Mr. Justice Marcus Smith has held. And of course, my lord, I showed you Mr. Snowden's submission. Your lordship was picking up Mr. Snowden's submission. And clause 5.1b is the solvency condition on which PLC places all its emphasis in this case.
But I mean, the fact it's not correctly characterized as a condition doesn't necessarily mean it's not the right place to find the answer. I mean, it's a question of construction, of course,
Well, of course.
Of the thing read as a whole.
Of course, one has to construe it, and one has to construe it correctly, and we will do that in due course. One of the things that your lordships will see is that what led, in part, Mr. Justice Marcus Smith into error is that he's separated out the different elements. He's decided that 5.1b creates a contingent debt, and he's then applied that separately, and it led him into confusion. But my lord, you're absolutely right. We've still got to look at the clause to find the answers, and I hope I will do that.
I'm sorry, I don't want to take you out of your course at all. I was just perhaps laying down a bit of a marker. I mean, there's also, I think, there is much force in your criticism, at least it seems to me at the moment, that the judge was, as it were, over-analytical in the way he divided up the clauses into little morsels. And it was really, it needed a sort of synoptic view rather than an ultra-salami slicing one.
My lord, that is our submission. And the relevance of contingent debt, that is not the sole point. The relevance of contingent debt is, of course, it has consequences to how it fits into the statutory scheme. But But one of the very important points is, of course, your lordship, the Supreme Court, just over you're construing the conditionalities in this case, And that's one of the reasons why I'm, I hope, not labouring it too much. In paragraph 39, it starts with there's no express prohibition on the subordinated on proving in clause 5, but again, there is, with respect, no addition of the impact of the contractual subordination, because that's what contractual subordination does. And then your lordship picked up towards the end of 39 the point that clause 7e, which had been relied on, and your lordship made the point that you can't rely on 7e as prohibiting the action. You have to look, decide the extent of the subordination, and you say that is found in clause 5, not in clause 7. And we respectfully agree that, with your lordship, that subordination is not found in clause 7. And then paragraph 41.
I'm sorry to hold you up. The debate, as I recall, and I think it's borne out by looking at my judgment, was whether the subordinated creditors were or weren't entitled to prove. You haven't shown us how Mr. Justice David Richards dealt with that issue, on which I clearly disagreed with him. Just if you can give me a page reference, you don't need to turn it up now. I just want to remind myself about.
Maybe come back with the
yes,
page reference for your lordship's note. But no, you're absolutely right. But yes, and the reason why you got into contingent debt was Mr. Snowden's very clever argument, which was, of course, contingent debt can prove throughout. And so Mr. Snowden's argument was, this is a contingent debt, ergo they can prove throughout, ergo the decision that Mr. Justice David Richards had made, which was that a contractual subordination provision means that you can't prove until after the senior creditors. That was I'm putting it very basically. That's why he ran contingent debt, and your lordship was persuaded. And we'll move on, but I'll do that in a moment. So paragraph. Paragraph 41, where your lordship says, I would accept Mr. Snowden's argument that the subordinated debt is a contingent debt. It is contingent not because of its position in the rankings in insolvency, but because the subordination agreement itself provides that repayment is not due until certain conditions have been satisfied. So, my lord, we respectfully submit that that is the ratio of the decision. And that is relevant going forward. Yeah. Okay. And then, but shouldn't I just show them the order? Okay. Can I then just show you the order, which is in Authority Bundle 5, just to make good so you can trace the changes? It's in tab 85, and I wanted to take it to 2882. And my lords, it's order number 2, where order 1, which we've looked at, was varied to declare that the claims of LBHI2 under its subordinated loan agreements with Libby are provable in the administration or liquidation of Libby, but are subordinated to provable debts non-provable and are repayable only on contingencies, including payment of such claims. So that is the change that was made in the Court of Appeal. Before turning to the Supreme Court, I just want to make 2 points, if I may, which we would respectfully submit are material. The first is that that neither Mr. Justice David Richards nor the Court of Appeal held that the same subordination provision could both operate as precluding proof until a particular point and result in the debt being a contingent debt that could be proved at any time.
Sorry, say that again. Neither court.
Neither Mr. Justice David Richards nor the Court of Appeal held that the same subordination provision, which is clause 5, could both operate as precluding proof until a particular point, which is the effect of simple contractual subordination using the language and judgment in this case, and also result in the debt being a contingent debt that could be proved at any time. In other words, in neither Mr. Justice David Richards' judgment nor in the Court of Appeal's judgment did you get this bifurcation that we get in this case. And the second point, just to underline the point, is that the Court of Appeal held that the subordination took effect by way of a contingency under 5.1b, the solvency condition. And as I've indicated to your lordships, that was an important step in Mr. Snowden's argument. Because if the debt was contingent, it was part of the debts proved, and it would therefore rank for interest. That's why the argument was run. I then want to turn to the Supreme Court, which is in Authorities Bundle 4 at tab 58. And it starts at page 1809. Could you just cast your eyes over holding 1 and you'll see that the appeal was allowed in part in relation to the first question, and the holding records it would not be possible to lodge a proof in respect to subordinated debt until either the non-provable liability has been paid in full, or it's clear that after meeting the proof in full and paying debtor interest, the provable liabilities will be met in full. And then if we can go forward to 473 internal, which is 1817. That's just where they note the change in the Court of Appeal. And then we see, and perhaps this is one for your notes, but Mr. Miles had taken over from Mr. Snowden, and Mr. Miles ran the arguments that are being run by Mr. Beltrami before you. You might like to look at those in due course. Going on to 37. And if you could cast your eyes over 37, but note that what Lord Neuberger records is that the disagreement was over whether the subordinated creditors could prove and require the administrators to admit their proofs until after the proving creditors had been paid in full. So that was the issue. And then in 38, which records those issues, and you can see that the Libby administrators appealed the point on proof, arguing that the subordinated debt ranked behind statutory interest and non-provable debts, and they argued that Mr. Justice David Richards was right and LBH13 was not entitled to prove until the senior creditors had been paid in full.
So we said that it was subordinated. It was just a question of when you could prove.
My lord, you said it was contingent,
Yeah.
subordinated but using a contingent mechanism. For your notes, if we can go forward to 66, on 1846, paragraph 66, between letters D to the end of the paragraph, the point that Lord Neuberger...
66, letter G, did you say?
Letter D, sorry.
D.
D, apologise. In agreement with all parties, I can see no... Lord Neuberger there explains the limits of subordinated debt. And he explains that you can always agree to subordinate your debt, you can't agree to improve your position. Unless everybody who is being subordinated agrees.
Yes.
All of which brings me to 68 through, and I'm trying not to take too long over this. 68. Lord Neuberger sets out David Richards' decision and says the Court of Appeal disagreed. And picking it up above letter C, they said that until the senior liabilities have been paid in full, the subordinated debt would be a contingent debt, and because of the terms of the loan, and so on. And then in 69, he says, in my judgment, Mr. Justice David Richards' view on this point is to be preferred. The Court of Appeal's view appears to me to raise a logical problem. If at the time such proof was lodged, there is any chance that the senior liabilities would be paid in full, then as with any other debt which rests on a contingency that may occur, a valuation of that proof would not be nil. And that's why I referred to the point made in the South African case earlier, where he'd said the opposite. It would have to be a figure which discounted the sum due in order to allow for the contingency not occurring. However, the proof is ascribed a valuation greater than, if the proof is ascribed a valuation greater than nil, it would have to be paid out on any distribution. So, in other words, you value whether or not the contingency is going to be met. You then declare dividends, and as you go, the subordinated creditors are paid dividends before the senior creditors have been paid in full.
Yeah.
But
Lord Neuberger finds the answer to the question in clause 7, not in clause 5. What he says is that he prefers Mr. Justice David Richards' view that clause 7D or E has the effect of precluding the lodging of a proof. I had said I didn't think it did, and I was wrong about that. And then again, at 69, just below E, he says, as Mr. Justice David Richards said, that would appear to fall foul of clause 7. So it all turns on clause 7.
No, with respect, my lord, no, it
Right.
turns on two things,
Right.
because where does the Neuberger say? Because Lord Neuberger says that where you've got the effect of a contractual subordination clause, a simple contract, if it's in paragraph 70, it follows, in my view, it would not be owing to LBHO2 to lodge a proof in respect to subordinated debt until the non-provable liability had been paid in full, or at least until it's clear that after meeting proof in full and paying any statutory interest due on it, the non-provable liabilities could be made in full. As soon as that's happened, there would be subject to what I say, and there's nothing to stop them lodging in late proof. That does not depend on clause 7. It doesn't, my lord, because your lordship has seen, going right back to Mr. Justice Weinlot's decision, and it's a point that Mr. Justice Marcus Smith got right, which is that where you agree that you will be subordinated to a senior creditor, you cannot prove until. Clause 7, as your lordship rightly said in your lordship's judgment, does not determine the degree of subordination or when you can prove. You have the point at which you can prove from the agreement.
Well, that's what I thought, but that doesn't seem to be what
I know
you
there are
thought.
no, my lord, there are 2 points running in parallel here. One is the contingent debt analysis, and that is what the Supreme Court disagreed with. The second is when under contractual subordination provision you can prove. And if you agree that you will prove after the Supreme Court, after the senior creditors, you cannot prove as a matter of contract. You can't prove until after the senior creditors. That is precisely what happened in MCC, and the learned judge was right here. Clause 7 is not determinative. It is, as it were, enforcing an additional right to stop someone proving. But you can't. You see, if you take out clause 7 and ask yourself the question, could a subordinated creditor prove at any time absent clause 7? Of course not, because they have agreed to be subordinated as a matter of contract to the senior creditors, which means they have agreed not to prove until after the senior creditors have been paid.
But you presumably could do that through the mechanism of a contingency, provided that you undertook not to prove your contingent debt until other creditors have been paid out.
You could do it if your lordship
I mean,
is
the fact
saying
that it's contingent
is
doesn't necessarily mean that you can or cannot prove. You've got to look somewhere else in the instrument to decide whether or not you've agreed not to prove. And as I read what Lord Newberger said, he found that in clause 7.
Well, my lord, if your lordship's asking me, is it possible to have a contingent debt and you agree you will not prove your contingent debt? Of course it is. It's a matter of contract. You could do that. If you're putting to me that the only reason why they couldn't prove is clause 7, then I respectfully disagree.
Right.
Because once you have agreed to subordinate your debt to the senior creditors, you have agreed you shall not prove. And that is what you get from MCC. And that is also picked up correctly by the learned judge in this case. So my lord, the last paragraph, 72, is where the Lord Newberger restores paragraph 1 of the order made by David Richards. Because although I agree with the Court of Appeal, he was right as the ranking, I disagree with the Court of Appeal and agree with the judge as to when the subordinated creditors can prove. And what you get from the Supreme Court judgment on that run is the ratio, if I may be, well, no, I don't need to make excuses. The ratio of the case was clause 5.1b of the agreements we're looking at here on the sub-debt do not create contingent debt. So if I can then go to the judgment, which is in volume C2 at tab 22. And I just want to go to paragraph 121, which is on 379.
Can I put Mr. Beltrami's skeleton away? Or do you still want me to keep that one out?
No, I'm so sorry, my lord. Yes. Well, no, actually, I'm about to turn to
You
it.
are, all right. So I will keep it out.
So 121. And you'll also see that the Supreme Court agreed with Mr. Justice David Richards, and then there's a footnote and it says the Supreme Court disagreed with the analysis of the Court of Appeal, but if I'm right, the Court of Appeal viewed these provisions as amounting to contingent debt subordination. That disagreement was less to do with the right to prove and more to do with the difference of view between the various instances as to the nature of the clauses between them, before them. And what we'd say about that is that the judge identified the problem that there were two related issues, namely the right to prove and the nature of the clause, and in that case the nature of the clause was whether it created a contingent debt. But what the learned judge in our case went on to do, and you'll see this, is he held that the same FSA form, same clause, could still include a contingent debt component. And if, as we say he did, the learned judge concluded that this clause did include contingent debt subordination, it is contrary to the Supreme Court reasoning, and it was not an analysis that was open to him. And if I can then take up bundle C1, tab 8, which is my learned friend's skeleton, which your lordship has kept out, and just turn to (25) B and C. My learned friend says, if as appeared to be suggested for the judge, the submission is the Supreme Court in some way disagreed with Lord Justice Lewison's description of methods of subordination, either generally or with regard to paragraph 5.1, then PLC disagrees. The Supreme Court said nothing about the relevant paragraph in Lord Justice Lewison's judgment, none of which was controversial. That was your lordship's description of the different methods of subordination. And this is the Supreme Court did disagree with Lord Justice Lewison's subsequent views expressed as in addition as to when a subordinated creditor can prove for its debt, as explained above. This was in connection with an issue on which no point runs in the present case. And your lordships have seen that the discussion about whether or not it created contingent debt was, I would respectfully submit, the ratio. May I now move on, with huge apologies for having taken so long so far, to construing the LBHI2 sub-debt. Can we pick up at volume C3, tab 38?
I should perhaps have said when I was telling you what we'd read, that we have read the relevant provisions of the various instruments.
Yes.
Not only in the, as quoted by the judge, but also in their original form.
Right.
Can't say I read every single word. But
no, well, there's no need.
Subordination.
No, there's no need. Your lordships, well, may I take this at a bit of pace?
Well, you take it at your own speed, Mr. Phillips.
Yeah. Your lordships see in tabs 38, 39 and 40, there are three different sub-debt agreements, all in the same terms apart from the currencies. If you look at 670, you can see the heading, and then you get variable terms that start on page 671 and standard terms that start on 675. If we could go to 675, clause 1 is interpretation, which you will have seen, and the order in which I wish to take it is 676 liabilities. Liabilities is widely drawn, all present, future sums, liabilities, obligations, and so on. So that is a widely drawn provision in relation to liabilities. And then we see in 676 further down, senior liabilities. It means all liabilities except the subordinated liabilities and excluded liabilities. And the point is that anything that is not a subordinated liability or an excluded liability in this agreement is a senior liability. And with respect to anyone who says otherwise, that is as plain as a pikestaff. We then have subordinated liabilities, and they mean all liabilities to the lender in respect of the loan or each advance made under this agreement, and all interest payable thereon. So it's, again, it is only the advances under this agreement that can be the subordinated liabilities.
Is that an FSA standard term?
These are FSA standard terms. I think, was it?
Including the definition of subordinated liabilities and its restriction
Yes.
to under this agreement.
Yes, absolutely. And when we come to the amended notes, when we come to, to the notes, what you'll see is because they were in the form of notes, they had to amend it to take account of the fact that it was notes. But I'll show you that. The answer to your question is yes, there are standard form 10 and standard form 5. This is 10, is it not? This is 10. Subordinated, and then the excluded liabilities on the previous page means liabilities which are expressed to be, and in the opinion of the insolvency officer of the borrower, do rank junior to the subordinated liabilities in any insolvency of the borrower. The key words are expressed to be and do rank junior to the subordinated liabilities. So you have an expression of juniority which you will find in the excluded liability. That's where you will find that. They express themselves to be junior. And then if we can go forward to 6, 7, 8.
So at this stage, you don't know to what debts you have subordinated your entitlement under the loan agreement until you've looked at all the other instruments which may or may not contain expressions of juniority.
They're junior to you, as in what is cut out. The excluded are junior to this instrument.
Yeah. Well,
you're absolutely right.
As far as other loans under different agreements are concerned, we can forget subordinated liabilities because that's limited to what's advanced under this agreement. So if we're looking at who else does or doesn't rank senior to this debt, you've got to look at the terms of whatever instrument it was that created that other debt and ask yourself, does that other instrument express itself to be junior to this one?
Absolutely. Absolutely, my lord. And in the context of these forms, your lordships will have picked up, it's regulatory capital. The point is that you are subordinating yourself to the bank or the businesses, if I can call it business debts, outside debts. And the capital is there to support those debts. That's the point. If we can then look at clause 5, which is 6, 7, 8. And my lords, your lordships can see this clause 5, it's headed subordination. I don't know whether you've done the same exercise as I have, but the judge broke this clause and all the other clauses down into numbered phrases. For your lordship's note, you'll find the numbers for this clause at 140, which is at C2 22 385 if you wanted to. Looking at 5.1, this is phrase 1. The rights of the lender in respect of the subordinated liabilities are subordinated to the senior liabilities. It identifies the rights of the lender it provides that those rights, and it is in respect of the subordinated liabilities, are subordinated to the senior liabilities. Those senior liabilities are the liabilities you have seen defined in clause 1. And in paragraph, perhaps we should take out C2, tab 22, and just look at 2 paragraphs. But in paragraph 140, as your lordships will have picked up, if you go to 387, well, starting on 386, you can see that he describes 5.1, and then on he sets out that breakdown, and then he says in 142, in my judgment, and subject to the effect of the words "and accordingly," which of course we'll come back to, the effect of phrase 1 is to subordinate subordinated liabilities to the senior liabilities in the waterfall, and to prevent, at least in an English insolvency, the lender from proving in that insolvency until the senior liabilities have been discharged. And he refers back to his explanation in 122 of how simple contractual subordination works, and it is to the effect of the submission I've been making to your lordships, that if you subordinate yourself to the senior creditors, you cannot prove until after the senior creditors have been paid. And then going back to the clause, and I've just put the judgment to one side, going back to the clause, phrase 2, and accordingly. And that is the first of 3 and accordinglys throughout the phrase, the clause. So, and accordingly, payment of any amount, whether principal, interest or otherwise, of the subordinated liabilities is conditional upon. And that follows on from the subordination of the rights of the lender. It is the right to payment, and accordingly payment. And that is what is made conditional upon 2 things. 5.1a applies outside of an insolvency, and you'll have picked up that the conditionalities are different inside and outside of an insolvency, and the reason for that is the mechanics of payment are different inside and outside of an insolvency. Inside an insolvency, as I indicated, shown your lordships, the only mechanism of payment is proof and dividend. And then we get to 5.1b, which gives the condition that applies both outside and inside, which is phrase 5. So this is conditional upon the borrower being solvent at the time of and immediately after the payment by the borrower, and then you payment by the borrower, and then you get another and accordingly. No such amount which would otherwise fall due for payment shall be payable except to the extent that the borrower could make such payment and still be solvent. So it's conditional on the borrower being solvent, which means payment can only be made if the borrower will remain solvent after making the payment. And that takes you to what is solvent, which you get over the page in 5.2, which is numbered phrase 6. For the purposes of 1b above, the borrower shall be solvent if it is able to pay its liabilities, capital L as defined, other than the subordinated liabilities, in full, disregarding obligations which are not provable or capable of being established or determined in the insolvency of the borrower, and B, the excluded liabilities. Now, 5.1 and 5.1b are connected by the words accordingly. The natural meaning of the word is to be read in our submission as connecting 5.1b to the subordination of the senior liabilities. And for your reference, we have at AB 832869, the Oxford English Dictionary, accordingly meaning therefore, so, or as a result.
Yeah, in consequence is how I would normally.
In consequence. Yeah.
So 5.1, the first rubric, tells you the general principle, and 5.1b tells you one of the consequences of it, at least in an insolvency.
Not the only consequence, though, but yes. Yeah. And the effect of the solvency conditionality is entirely consistent with the simple contractual subordination to the senior liabilities. And the reason why I say that is that, in essence, LBHI2 needs to be able to pay its senior liabilities. If you look at what it is that they have to be able to pay in order to be solvent, it's everything other than the subordinated and the excluded. It's the senior. So it's all of a piece. They need to be able to pay the senior liabilities in full, and the creditor does not have the right to payment, which in an insolvency means the right to prove, until that point. And contrary to what the learned judge held, the solvency conditionality does not have an independent, let alone contrary, effect which can be decoupled from the subordination to the senior liabilities. It is a whole. It is one clause. It provides that they're subordinated to the senior liabilities. It provides that, and accordingly, you can't prove until you can pay can pay the seniors.
Yeah. So the question then is the claim under the notes an excluded liability? That's what it boils down to, doesn't it?
Yeah. So may we turn to the unamended subnotes? The next thing I'm going to do.
Why don't we start with the amended ones? They're the current ones.
There are all sorts of reasons I could take time explaining.
Well, do it in a few minutes, because looking at the instrument as it actually existed at the date of the insolvency seems to me to be the obvious starting point.
The first really important point is that the terms of the unamended notes continue to apply after the amendments. Clauses 1 to 7 apply throughout, and they're not amended. And it's a very important point, because one of our major criticisms of the judge and the judge's reasoning is that he went to what he calls phrase 8 and following, and he ignored phrases 1 to 7, including this phrase 2 that we've just looked at, which is the contractual subordination provision, and he ignored it. So we have to construe that, if I may respectfully submit, in the unamended notes first. And the other point is that the clause is not amended at all outside the winding up. So you've got the definition of senior creditors not amended. The operation clause outside the winding up is not amended. And the conditionalities in the subnotes do not alter the legal characteristics of the senior creditors to whom the subnotes are subordinated. And it's important to construe the definitions and their interplay with the conditionalities, both under the unamended notes and then under the amended notes in our submission. And part of the construction exercise for your lordships is going to be to compare the commercial consequences of the parties' possible interpretations. And to make that comparison, your lordships are going to need to look at what happened outside of winding up and what happened inside the winding up, because as your lordships will already have picked up, one of the consequences of the judgment is that outside of a winding up, the subnotes are senior, and then inside a winding up, they are junior. And in our submission, we need to look at all those. And then, of course, there's the rectification question, which is going to follow on from that. So if I may respectfully just turn to those unamended first.
Well, what the notes mean is what they would mean to the reasonable reader of the document which creates them. Is that right?
Yes, of course.
And they are tradable financial interests listed on the Channel Islands Stock Exchange. Now, it's true that as far as the Lehman companies were concerned, they didn't intend notes to go outside the Lehman Group, but that, I would have thought, doesn't affect the meaning of the document.
Not outside of rectification,
No.
Absolutely.
So if somebody were to buy into these notes because they're traded on the Channel Islands Stock Exchange, they would see a clean print, would they not, of the amended notes and would not have access to what had gone before.
Yes.
So why are we starting with the unamended notes when somebody who is looking at the notes at the date of the insolvency would only have access to the amended version?
You just give me one moment, because when your lordship say, I didn't want to take you out of your course, this is quite dramatic.
Well, as I said, I thought we should start with the amended notes.
Okay, and then I don't know how much I'll have missed. Can you think about how much I'll have missed? Forgive me, I'm just trying to...
You don't need to answer that now, but I'm just trying to explain to you why I thought we should start with the amended notes. But you disagree, you want to start with the unamended ones. That's fine.
I'm absolutely not tone deaf, and I will go to the amended subnotes, and then we will apply our minds to see whether or not any submissions that I was making in the earlier context I need to pick up again. I'm afraid I'm not smart enough to be able to do that on my feet.
Yeah.
So let's turn to the relative ranking of the subdebt in the amended LBHIT subnotes. And my lords, as I've already indicated to your lordships, the learned judge held that on the unamended language of the subnotes, the subdebt ranked below the subnotes. And for your note, that was paragraph 198 of his judgment. And he held that the amended subnote ranked for distribution below the subdebt, which is, for your lordship's note, 233 and 243, which meant that the judge held that the effect of the amendment was to reverse the relative ranking, which he said at 231 was surprising. And our position in relation to, just to be clear, in relation to the priority dispute between the ranking of the LBHI2 subdebt and the amended subnotes, is that the claims under these instruments rank pari passu. That is our submission throughout all of these entities. The effect of the judge's conclusion, and of course we'll look at this when we turn up the documents, but the effect of the judge's conclusion is that the amended subnotes have within them two distinct regimes. The first outside of a winding up, which is where claim A, the subnotes, ranks below claim B, the subdebt, and the second regime in a winding up, where claim A ranks above claim B. And that is because the further conditionality, which was inserted by the amendments, is only engaged, as your lordships know, in a winding up. And again, we say that is highly surprising and in our submission wrong. The ratio of the judge's decision was further conditionality in the subnotes had the effect of subordinating the subnotes to all other subordinated debt, save for debt that utilised the preference share deeming mechanism. The judge reasoned that the LBHI2 subdebt did not utilise a preference share deeming mechanism, and therefore that the subnotes ranked below it. And your lordships have still to answer the question in relation to the amended subnotes, which is, what is it that defines the point at which claim B under the subnotes can prove? And the ancillary question of why did it subordinate the subdebt for so long that the company was outside of a liquidation, but subordinate the subnotes if it went into a liquidation? So I'd respectfully submit that on any view, that is a very odd result. And the judge also held that the further conditionality operated independently, entirely independently in the amended subnotes. And he held that there was no need to apply the definitional wording. In our submission, the judge was wrong, and he failed to construe a composite subordination provision in a unitary way. He failed to apply the definitional language, which remained unchanged in the amended LBHI2 subnotes, and he did not have proper regard to the fact that the language of the further conditionality only addressed the position above which debts the LBHI2 subnotes sit in a winding up. It said nothing as to which creditors the LBHI2 subnotes are subordinated below, which continued to be a question addressed solely by the unchanged definitional wording. I've been handed a note asking whether the transcribers needed a break.
I agree to transcribe was on the understanding there would be no breaks. We've got a lot to get through.
Thank you. So, can we turn to, I hope you've still got, or can we turn to bundle C3?
Yes.
Tab
42.
42. And again, my lords, the judge numbered the different phrases, and that he did that at paragraph 203. So if we can turn to 741, please, and it is in the notes. It's clause 3, which is headed status and subordination. And the first point is that, as your lordships can see, and my lords, your lordships have underlining, but as my Lord Justice Lewison rightly pointed out, that underlining would not have appeared elsewhere, but it's helpful for our purposes so we can see what the amendments were. The first point is that you can see that everything above the underlining is...
No, you're looking at the judge's
oh, I'm sorry, I'm
quotation
doing
of
it from here.
from the judgment.
No, my lord, I've numbered, I'm doing it on page 741.
Right,
in bundle
my
C.
741 is a clean print without any underlining.
Ah, I do apologise.
I can get the underlining from the way the judge quotes it,
Yes.
but
I now I understand. I do apologise. I've got underlining, but anyway,
right.
not a problem. The point that I was making was that everything down to what is numbered 7, but you're not looking at that. Anything down to the conditionality referred to above will not apply. Everything above that is unamended.
I thought including arrears of interest as defined below was one of the amendments.
You're quite right. Apart from and interest, including arrears of interest as defined below, subject as provided below in the brackets in line 5. Your Lordships might want to actually underline it yourselves. But thank you.
Yeah.
But I wanted to start, if I may, just go through this. The notes can constitute direct unsecured subordinated obligation to the issuer, and the rights and claims of note holders against the issuer rank pari passu without any preference among themselves. That's dealing with pari passu ranking amongst the note holders. And then this is numbered clause 2, the next phrase. The rights of the note holders against the issuer in respect of the note are subordinated in right of payment to the senior creditors as defined below. That is phrase 2, and I'm being suggested by Mr. Wilson that would make it easier for you if you had page 200 and paragraph 203 of the judgment open as well, which is C to 22.409. Just in case I refer to a phrase number and you wonder where I'm going. Now, that language, which is phrase 2, the rights of the note holders, is unamended language. And in answering the key question, after which senior creditors is the note holder entitled to prove, the answer is the same pre and post amendment. And it is to be found in phrase 2 and the express definitions, which I will turn to. Phrase 2, that I'm now referring to, contains the only language in condition 3 which deals expressly with the question below whom the LBHI2 subnotes are subordinated. And you've got those words there, are subordinated in right of payment to the senior creditors. There is no other express wording which describes below whom the LBHI2 subnotes rank. That wording in phrase 2 is followed by the words in brackets as defined below, and that is a reference to the definition of senior creditors which is found in phrases 24 to 30 of the provision. As the words as defined below cannot be a reference to the further conditionality, because that is not a definition. It contains, the further conditionality contains no definitions relevant to the senior creditors. So if we may turn the page to 742. And do your Lordship see in B, where it starts, for the purposes of the above provisions, yes. That's numbered clause 24. Numbered clause 25, but it goes on, senior creditors means creditors of the issuer. 1, and this is 26. Tell me if me telling you the numbers is unhelpful.
Well, I'm looking at the clean print.
I'll take that as a yes. Who are unsubordinated creditors of the issuer, or 2, who are subordinated of the creditors of the issuer other than. So the first point that you get in 1 is it identifies unsubordinated creditors of the issuer. And that is creditors who are not subordinated in any way. The second is who are subordinated creditors of the issuer other than those with whose claims the claims of the note holders are expressed to rank pari passu, and those whose claims rank or are expressed to rank pari passu with or junior to the claims of the note holders. Can I break that down? So it is subordinated creditors, in other words, creditors with some subordination other than particular creditors. So these are creditors who are senior creditors, but who have subordinated themselves to other senior creditors. Whether you call them subordinated senior creditors or senior subordinated creditors matters not. They rank senior to the notes. The other than then identifies those who are not senior. And the first is those with whose claims the claims of the note holders are expressed to rank pari passu. That is creditors who are expressed to rank pari passu in the notes. So the expression of pari passu will be in the notes. And it's, on this conversion, it's the note holders, the other note holders. They all rank pari passu amongst themselves. The next is those whose claims rank or are expressed to rank pari passu. Put junior to one side for the moment. I'll do junior after pari passu. So the first is those whose claims rank pari passu. That is a recognition of a state of fact, that they rank pari passu. We have already seen that there's an expression of those whose claims are expressed to rank pari passu, and we've got rank, which is where they in fact rank, and that could be as a result of either the judge's approach, or if they prove after the same senior creditors, they will rank pari passu. And then you move on to those that are expressed to rank pari passu, and that expression of pari passu ranking will be found in the other instrument. So that there's an instrument that expresses itself. I rank junior to the same senior creditors. I rank pari passu with the subnotes. And then we move on to junior. Those whose claims are expressed to rank junior with the claims of the note holders, and you would find the expression of juniority in the other instrument. So somebody is.
Right. I must say I read the words or junior to as being governed by rank or are expressed to rank, not by expressed to rank alone.
No.
For what it's worth.
Well, my lord, that's if I may respectfully say, is likely to be, because I've thought about this, likely to be a distinction without a difference, because in order to rank junior, they have to express themselves to rank junior. And it's very hard to conceive of someone ranking junior without having subordinated themselves. But I'm not sure I can help you further with that point, but I understand. Sorry.
So the definition of senior creditors,
Yes.
amongst other things, recognises that there can be relative priorities as between subordinated creditors.
It does. The other point that I would just make at this stage is that what is a senior debt is defined by reference to seniority and juniority. In other words, where they have agreed to rank, it is not defined by what type of conditionalities they have subjected their debt.
Well, would you not have to construe the instrument as a whole to find out if there is an expression of juniority somewhere? There was no special form of words, is there, that you, or perhaps there is a special form of words?
No. The point I was making is that when one looks at this definition, what it is saying is identifying where people rank, and it's the definition looks at seniority and juniority. What it doesn't do is it doesn't say, if a debt is payable on certain conditions, then it will rank as whatever. I take your Lordship's point. You still have to construe the whole clauses in each and every case, and I'm not shying away from that for a moment, but I was just observing that those definitions identify seniority and juniority. Sorry, Mark.
I mean, you accept in principle then that it's possible for subordination for these purposes to be contained in something that is phrased as a condition, if on the true construction of the provision read as a whole, that is the effect which it's intended to have.
Well, the crucial point would be if on the clause read as a whole.
Absolutely. But you're not saying that there has to be some express reference to conditionality as such, or rather, but if there is an express reference to conditionality as such, that somehow precludes it being taken into account or having the result of the subordination.
Well, the circumstance in which one can imagine that is if you had pure contingent debt subordination. If you had pure, that was one of the three mechanisms, and if you had pure contingent debt subordination, it's not going, well, I'm saying it's not. It will be, this debt is only payable
if everybody else has been paid out first.
Paid out first, which is a different approach to the contractual subordination that we're looking at. And at this point, we are looking at the contractual provision, if I can put it that way. And I'm going to come on, obviously, to the conditionalities. But at this point, I'm dealing with that. And they don't. Sorry, and I've done that. Sorry, forgive me. Yes. So the amendments to the further conditionality that we're going to come on to below this definitional wording, they don't, we will see, they don't convey any intention for the notes to rank behind different senior creditors to the senior creditors we see in this part of the clause, which we call the definitional wording. And when we look at it, you'll see it doesn't fundamentally alter the legal characteristics or identity of the senior creditors. And a point that we would make is that if the draftsperson had wanted to alter below whom the subnotes rank, it would have been the simplest thing in the world to amend that definition of senior creditors. If that's what they had intended to do, they could have included an amendment of that definition. So, moving back, if I may, to 3A, I think we've got as far as the accordingly, payment of principal and interest, including arrears of interest in respect of the notes subject to provided below, is conditional upon the issuer being solvent at the time of and immediately after such payment. So that's the first accordingly. And again, that was unchanged. And it makes it clear that in a winding up, the further conditionality applies, and outside of a winding up, the conditionality that was already there applies, and they both follow accordingly. And again, we construe that, that should be construed in the same way. And we then get another accordingly, which is, it's phrase 6, but it's 3, 4, 5, 6, 7 lines down. Accordingly, no such amount which would otherwise fall due for payment, and we'll note that it is again the right to payment, shall be payable except to the extent that the issuer could make such payment and still be solvent immediately thereafter. Now, pausing there, that is all unamended. Okay? And you should note that there is only one conditionality referred to before you get to the words the conditionality referred to above. And the conditionality is conditional upon, which you have seen.
And the second and accordingly is a way of describing the first.
Yes. Yes, no, I'm so sorry, my lady. Yes, absolutely.
In fact, you could strike out those words, not that I'm suggesting anyone does something like that.
No, absolutely right. We then move on to the conditionality referred to above shall not apply. And the point is that that is not saying that all of what are numbered phrases 2 to 6, what's gone before, are disapplied in a winding up. And in particular, the words, the rights of the note holders against the issuer in respect of the notes subordinated right of payment to the senior creditors is not a conditionality. That is not disapplied by those words, the conditionality referred to above shall apply. Now we then go into the conditionality, and what you will see is that this conditionality adopts a fiction of a hypothetical class of preference share, which has certain characteristics. And it does not, contrary to what the judge held, say that the notes are subordinated alongside preference shares or, for that matter, any other issued shares. So can we have a look at that? The conditionality referred to above shall not apply. As I've submitted, that's only conditional upon the issuer and so on. Where an order is made by a competent court or resolution passed for the winding up or dissolution of the issuer, except for the purposes of reconstruction, amalgamation, reorganisation, merger or consolidation on terms previously agreed in writing by an extraordinary resolution of the note holders. And we then get to the new conditionality.
Just pause for a moment. The judge held that winding up included administration, and as I understand it, there's no dispute
we're not appealing that point. Yeah. Okay. Yes, my learned Mr. Wilson rightly points out that I'm about to refer to the numbers quite a lot. So if it's not too difficult to at least have them in view.
Yeah.
And I'm sorry if that was just a daft way of proceeding, but that's what I've done. So we get to the further conditionality, and that's in what is phrase 8, which is if any time an order is made, and we've dealt with that, And then it says in 9, there shall be payable by the issuer in respect of each note, such amount, if any. So the starting point, again, is it is describing payability in an insolvency, which can only mean through the proof mechanism, proof and distribution. And in brackets it says, in lieu of any other payment by the issuer. All I can say is there can't be anything outside of insolvency. Such amount, if any, as, and this is 10, would have been payable to the note holder. And then you get into the fiction. As would have been payable to the note holder if on the day prior to the commencement of the winding up and thereafter such note holder were the holder of one class preference shares in the capital of the issuer, having a preferential right to a return of assets in the winding up of the issuer over. Now, as to this language, first, it makes clear that we are dealing with a hypothetical construct. The notes were dated pre-amendment and remained dated debt post-amendment. They were dated debt throughout. They did not become preference shares or any other sort of share. The hypothetical nature of the concept is made clear as a matter of language by the use of the subjective mood if such note holder were the holder of one of the class of preference shares, which is an indication we are not dealing with real or actual shares. I appreciate it. And it's also worth noting that there is no wording here which links this conditionality to phrase 2 or to the definition of senior creditors, which could support the conclusion that this language is somehow intended to redefine the legal characteristics or identity of the senior creditors, and also behind whom the notes are subordinated. And that, my lords, is significant because we are construing a single clause, and this single clause has said the rights of the note holders are subordinated in right of payment to the senior creditors. They are defined. Nothing in this amendment has altered that part of the clause. The next point that we would make is that the further conditionality is confined to expressing over which categories the LBHI2 subnotes sit. Thus, in the phrase we're just looking at, which is phrase 10, the notes are defined as having a right over. And if we then look at who they have a right over, it is the holders of all other classes of issued shares in each case for the time being in the capital of the issuer. So, over the holders of all classes of issued shares, and over the notional holders. And you have then got an important phrase which is numbered 13, is on the assumption that such preference share was entitled to receive on a return of assets in such winding up an amount equal to the principal amount of such note, together with arrears of interest, if any, and any accrued interest. And that tells you that the right you are proving in relation to is not only as a debt, it's the principal amount of the note plus interest. That's the debt sum. and that was important to distinguish the notes from equity. So we then we looked at the notional holders who they have a right over, and we then go on 741. What is clause 14? Phrase 14 is for the purposes of the above provisions, and then we get this, which is 15. Notional holder means any creditor of the issuer. That, therefore, they have a right to prove over a particular type of creditor, which confirms it cannot possibly be a preference share, in fact, whose claims against the issuer on a winding up are quantified as though they held a notional share. So you get another notional share, which means any notional and unissued shares in the capital of the issuer, which have a preferential right to return of assets in the winding up of the issuer, over the holders of all other classes of issued shares, for the time being in the capital of the issuer, but not further or otherwise. A few points on the language. First, it refers to notional and unissued shares, not to issued shares, confirming that this is not dealing with real shares, preference or otherwise. Second, the right to a return is stated to be above the issued share capital of LBHI2. That necessarily would include preference shares. The starting point is that it ranks above all shareholders, and of course an unissued share would not in fact have any right to a return, which again confirms the notional nature of this mechanism. In addition to ranking above all shares, it ranks above the notional holder. And the notional holder is a type of creditor. The creditor of the issuer whose claims are quantified as though they held a notional share. And those creditors rank below the notes. And those creditors would be the upper tier 2 creditors. Fourth, a notional share means any notional and unissued shares with a preferential right to return of assets in the winding up, again over the holders of all other classes of shares. Again, the use over, which I think appears 3 times. And this is really an important point, the use of over, because the further conditionality refers only to the debts over which the LBHI2 sub-notes sit. As you've seen, it includes the notional holders, it includes the issued shares, but it says nothing about below or under which debts the notes are subordinated. I see your lordship is troubled.
I'm a bit, because it's common ground, as I understand it, that save with the agreement of all other creditors of the same type, a creditor can't promote himself further up the waterfall.
Yeah.
So, although you're quite right in saying that the note uses the word over, it can't have the effect of promoting the creditor, since the whole object of the subordination provisions is to demote the creditor from somewhere. It must be part of the demotion.
And my lord, that is why you have to read this as a whole.
Yeah.
Because this clause subordinates these notes to the senior creditors as defined, and the creditors who appear in the conditionality do not fall within the definition of senior creditors.
Well, that point I understand, but
yeah,
the point you were just making seemed to be suggesting that in some way the notes could tell you above whom they
the-
ranked, but that's what was bothering me.
No, I completely understand, my lord. The clause is not promoting the notes. The clause is describing who ranks below them.
Yeah.
But the clause itself, that amendment is not promoting the notes. The subordination of the notes is what's dealt with in phrase 2 or whatever one describes it as. And one then gets a description of who it is above. Now, I don't want to tread too far on to the rectification side of things, but the concern was that the notes might qualify as equity. And Mr. Bayhell wanted to make sure that it could be clear it wasn't equity. And that's what this is doing. But you know, I'm not trying to trespass. And then, sorry. So that was over. Yes, and we've seen it in phrase 10, phrase 16. But then there is an important point, because the subordination is provision, which I call phrase 2. That subordination provision, that express wording, makes it clear that the LBHI2 subnotes are not subordinated to all subordinated creditors. We've been through that. It doesn't subordinate it to all subordinated creditors. There are some, as you've seen, who remain senior. And the learned judge's reasoning is inconsistent with phrases, the definitions that we see, other than those whose claims, the claims of the note holder express to rank pari passu, and those whose claims rank or express to rank pari passu, because if you then go on to say that this conditionality subordinates you to every type of debt, subordinates the notes to every type of debt other than debts that have this mechanism, you've just, that's inconsistent with the definition of the senior creditors. And that's one of the reasons why construing it as a whole in our submission is so important. And one of the reasons why we rely on the fact that it's describing over is that that isn't promoting,
No.
but it's equally, it's not subordinated.
Would there be anything wrong in a loan agreement which said, I'll lend you £1 million, but in the event that the court makes an administration order, you need only pay me back 400,000? I'll rank pari passu with the other creditors, but I won't claim more than 400,000.
Proof for 400,000. So you're not saying you will pay me 400,000,
No.
whatever the dividend.
No, that would
No, there's nothing
fall
like
foul.
that.
So what's wrong with notes that say, well, I'll rank pari passu with other creditors, but you only need to pay me what you would have paid a preference shareholder, or I will only prove what a preference shareholder would have got.
The problem on this clause with that is that it's inconsistent with clause, what's 13, which is that it's on the assumption the preference share was entitled to receive a return of assets equal to the principal amount. And that's the tension your lordship runs into on this clause.
Right.
Sorry, yes, and as we are on phrase 13, that language deals with the tax concern identified by Allen and Avery, which the learned judge refers to in paragraphs 206 and 207 of the judgment. And the concern was that payments on the subnotes could have been dependent on the business's results, and that created a risk, so it was thought, that the subnotes might be treated for tax purposes as equity rather than debt. And Mr. Grant addresses this in his witness statement. Yeah, if we could, sorry, if we could just get hold of supplemental bundle 1, tab 1, page 14. Sorry? This is what the learned judge was referring to in his judgment. So, page, internal page 14, paragraphs 29 and 32. If you could, so sorry. Just so you know, Mr. Grant was the draftsman at Allen and Overy, the solicitor at Allen and Overy who drafted the amendments. It was 29 in which he identifies the risk that the subnotes may be treated for tax purposes equity rather than debt. And then in 32, if the winding up was an insolvent one, then the claim of the note holders be limited by whatever amount remained at LBHO2 after the payment of senior creditors, which could be less than 100%. Mr. Deha wanted to ensure the note holders would be able to claim for the full 100% their entitlement, albeit with the claim being on a subordinated basis. So, my Lord, that confirms, as it were, what the intention was behind that language, which said you can prove for 100%. So, my Lords, I've shown you the amendments, and from that you can see that there is a double fiction introduced by a hypothetical preference share. First of all, when considering what is payable on the preference share, you consider the rights are above those of the notional holders. And secondly, you operate on the further assumption that the preference share is entitled to receive 100% of principal and interest, which, as I've indicated, was the tax part of the construct which the judge referred to. And the reason why I draw those to your Lordship's attention is that is far removed from an actual preference share or from ranking the notes as quasi-preference shares. We've thought about this, and we are unaware of any preference share entitled to 100%. Okay. Of principal and interest in the winding up. But before I do the confirmatory notes. My Lords, I was about to move on. Mr. Wilson helpfully points out, I was about to move on to the confirmatory note, and I just wonder if that would be a convenient.
How long is it going to take you to do this? Is the notes are intended, that bit?
Yes.
How long is that going to take you?
10 minutes.
A minute? What
10 minutes.
10 minutes, all right. Well, let's do that after lunch. All right, 2 o'clock. We're still on time, presumably, with the timetable that we've been given.
I hope so, my Lord.
Good.
All right.